Hello, my true crime lovelies. How are you? I hope you are well. I hope you are as lovely in life as you are in my mind. All right, we're ready for part two of the foolishness and chicanery that is known as Sarah's pre-trial compliance document that she filed with the family court. Hopefully, you've seen part one. We're just going to go straight into part two. And some of it is redundant. So I am not going to, well, let me back up. There's a lot of gaslighting. And so, I like to bring the receipts. So I have all the receipts, but if I showed the receipts in part one, I'm not going to show them again in part two because she repeats herself. So if you haven't seen part one, make sure you watch that as well. Eventually, this will all be one video, but just know that coming in. If you haven't seen part one, some of the receipts may be missing for you, but we're going to get into it. I think the key takeaway for me, Sarah wants all of the alimony, $61,000 paid to her. So much for all of her, she's always searching for solutions and being agreeable. She's not. She wants the same thing as if she were never incarcerated. And she wants it paid out monthly over 18 years, which I think is ridiculous. It's like Brian having another baby with her. But let me not get ahead of myself. We're going to run the intro, thank all the members, and we'll get into it on the other side. Alrighty, here we go. We left off on page 12, so we're going to start there. Basically, she's accusing them of overruling the court, which they can't do, and not seeking permission regarding visitation. That's where we left off. So we're going to pick up. She, as in Sarah, she believes the primary reason for both still not submitting to date. So she's talking about the application for visitation, and she means both Brian and Brian's attorney haven't submitted the application, she's alleging, is because he has to enter his employer's information, name, address, phone number, which would perjure his statements of unemployment and prove the respondent's ongoing truths regarding his income and ability to pay. So let's go into that, because you don't actually have to put in your employer's name, address, and phone number as exhibited by Peter Gunthel's application. We see here, place of employment, he put nothing, right? Employment status. And there's no place to put on here address or phone number. You could put your work number here, but presumably that would be like your direct desk number, right? So what she's saying is just not true, but she wants to accuse Brian of lying about his income and being unemployed. Even though they're talking about visitation, about her son visiting her in prison, she does not want to miss an opportunity to disparage her former husband. She goes on, no stipulation is entered in any agreements between the parties regarding the suspension or termination of the existing order of alimony upon incarceration. So we're back into alimony, even though we were here talking about visitation and him not complying with what she alleged was a court order. But in part one, we looked at what the minutes were from the hearing that she's referencing, the pre-trial conference, and there was no order for him to fill out an application to visit her. Okay, so no documentation has been entered with permission to do so by the court, so she's still salty that he just stopped paying alimony. Petitioner has not been granted by any judge in this family law case to cease or reduce his alimony obligations to the respondent. So I underline cease because obviously cease means to stop. And I would say it's more like a pause pending the hearing. Now, the judge could grant it because his motion was for reduction or elimination of alimony. So if he wins his motion and he gets an elimination, then yes, it's a cease. But right now it's pending because his motion hasn't been heard yet. But she likes to use these inflammatory words, right? Regardless of respondents' incarceration, she still has basic living expenses within the facility, such as hygiene items, communication, phone calls, tablet message, video visits, medical copays, weekly facility draws, and other essential costs not covered by the institution. So I'm going to say basic living expenses are not part of a weekly facility draw because that's the Florida pay to stay rule that they have, right? So they charge her for housing her. I don't know that Brian should have to pay for that. Excuse me, he didn't lock anyone in a suitcase. Okay, she also faced priority cost, such as her son, securing her vehicle, storage unit, 30-year bank account. That one we haven't heard in a while. She's blaming Brian for the loss of her 30-year bank account. Affording vital evidence in her defense and a possible attorney to represent her in this case. So I think defense is an interesting word. She's the respondent in this. She's not a defendant. She's not being attacked, but she takes that defensive position, right? Because if she were really working to be cooperative, they would be partnering and collaborating and solution oriented, which she is always attesting that she is, but yet she views herself as defending herself, right? So she's not really cooperating and thinking about what's best for her child and what's best for the household of her child. She's defending herself against what she feels entitled to, which is Brian's money. She feels entitled to take it out of the household where her son is. All of which has been lost due to the willful refusal of legally owed alimony payments being made to the respondent by the petitioner and without the court's permission to discontinue. She's going to hammer that home. The court didn't say you could. Hasn't said he couldn't yet. Suspending or terminating the respondent's court-appointed alimony also creates greater vulnerability and hardship to reintegrate into society overall. So I just put a question mark there. Ma'am, you're doing life without parole. What integration into society? And why is that Brian's responsibility? And with her son foremost, to rebuild a life together successfully upon the active outcome of her pending appeal and in the meantime of. So the court can't deal in never land, right? So if and when she gets an appeal that gets her out of prison, because there's two steps, right? First, you have to be, there's three steps. You have to be granted an appeal. Then the appeal has to give you relief, giving you what you asked for. And then 3, you need a new trial and you need to be exonerated in that trial. The court, that's a lot of what ifs. So Judge Jackson is not going to be considering that in her orders. At that time, Sarah could then file her own motion for a substantial change in circumstances, right? But we can't deal with the imaginary. And what's the likelihood that all that would happen for her? Her son's going to be 15 this October. That all of that would happen by the time that he's 18. It's like such a slim chance. But Sarah apparently believes in miracles. The respondent is very simply trying to maintain financial dignity and support while confidently serving and working toward a stronger, more opportunistic future by finally receiving her lawfully ordered overdue alimony payments she has been unlawfully penalized to rightfully receive by the petitioner. She cites all of this case law. She gives the actual case, but she doesn't give why she's citing it or the appropriate applicable citations within the case law. So it's just a bunch of gibberish, really. I mean, does she expect the judge to pull all this case law, read through it, and try to figure out what she's talking about? Like what this applies to? Does it apply to the lawful, unlawful? Does it apply to the applications for visitation? Does it apply to him ceasing the alimony pending the motion? Like, what is the judge supposed to do with this list of case law? And as in any written document, you want to make it as easy as possible for the reader. The more work they have to do, the less inclined they are to give you what you want. If you want them to give you something, hand it all to them on a silver platter. Make it easy for them to understand what you're asking for. Respondent, but we're 33 pages in, so we know that ain't Sarah's bag. Resolutions. Respondent maintains that incarceration should not justify ending or reducing her lawful entitlement to alimony under Florida law, and which the petitioner and his counsel have been using as a means to deny her access to justice. The petitioner fails to demonstrate any substantial change in circumstances by refusing to submit requested financial documents to the respondent and court to prove otherwise. Tax returns, foremost, which would identify past employers he is claiming to not have had or any other forms of income. So she's accusing him of lying, right? She's saying he's got past employers that he's claiming not to have. Well, if you know this, contact those employers, ma'am. But also when she says he fails to demonstrate any substantial change in circumstances, his change in circumstances that he noted on his motion had nothing to do with his job or his income. He stated that he didn't want to pay because she's in jail. Let's look at this document. So this is his modification request, right? His substantial change in circumstances including but not limited to, the wife was arrested and charged with second-degree murder of her boyfriend. The parties have one minor child. Inasmuch as the former wife is in jail, she does not have the financial need for alimony or child support payments at this time. He's voluntarily deposited money into the account. Nowhere does he state his financial situation has changed. Now, as part of that, he has to submit his financial affidavit. On that financial affidavit, he does state that he is unemployed, both in 2022 and again in 2025. But he doesn't state that as the reason why he shouldn't have to pay. His reason is she does not have financial need for alimony or child support. She shares no time with the child, so I feel like the child support is a no-brainer. But the alimony was to help transition her from being a wife in a house that was maintained by a husband. She didn't work, to transition her to getting out and getting a job and getting reacclimated into the workforce. She's not doing that in jail. So I don't know what she's talking about, but she wants his financial information. She's really fixated on that. He has also committed perjury to the court by submitting I didn't switch it back. Here we go. He has also committed perjury to the court by submitting untrue documents, such as his financial affidavit, which does not match up to his regular spending habits: alcohol, cigarettes, video games, entertainment, travel, etc. Income from his family, $50,000 plus per year. Excess of selling the marital home. Now, to be fair, he doesn't list a mortgage, so his excess of selling the marital home could have gone to him buying his new home when he relocated, but she doesn't consider that. She is here inferring that his excess, that he made about $200,000. She has no basis for that. I mean, I guess somebody could look on Zillow for her and see the value, but we don't actually know what he sold it for. And more, while supporting a child and being supposedly unemployed, with no means to comply and pay his alimony obligation to the respondent as ordered. He never stated he has no means to comply, so she's like imputing that on him. I'm not sure why. She's just like, they have money, that family has money, and damn it, I'm gonna get some. Oh, Sarah. So let's see, what is she requesting the court to compel petitioner to? 1. Provide reasons for his underemployment for over 3 years to present with having the ability to work, and explain to the court how it is not deliberate. 2. Explain to the court his livelihood income while, quote, unemployed, end quote, and supporting the minor child for over 3 years ongoing. 3. Present any evidence of permission given by the court to reduce and terminate his obligation of alimony payments to the respondent. He hasn't terminated them. They're on pause pending his motion. 4. Specify the single reason for modification and why it was not determined and continued throughout the process of this matter to lawfully allow respondent to correctly identify and respond to in her rightful defense. So she's defending herself again, but there is only one single reason that he's given. For his change in circumstance. Shall we play it again? Former wife was arrested and charged with second-degree murder of her boyfriend after she locked him in a suitcase. Inasmuch as the former wife is in jail, she does not have the financial need for alimony or child support payments at this time. That's the only one on there. And then he goes into, he wants, because of that single reason, modification of shared parenting, termination of alimony. And he says it in this paragraph. The former wife does not have the financial need for alimony at this time and will not throughout the period of the durational alimony, which, if not earlier terminated or modified, would end with the payment due on April 1st, 2025. Also due to the former wife's admitted egregious behavior of locking her live-in boyfriend in a suitcase, which ultimately led to his death, she is not entitled to alimony. The termination of the durational alimony should be retroactive to February 25th, 2020, the day of the former wife's arrest and incarceration. In the alternative, the former husband requests that the alimony be reduced or at least suspended for the period of time that the former wife is incarcerated. Same reason, Sarah. Same reason. I don't know how you're going to defend that since you're so intent on defending yourself, though. In addition, respondent respectfully requests 5, sanction petitioner and his counsel for their willful violations of the court's orders of alimony payments to the respondent with active agreements and undermining its authority of consequences for their ongoing non-compliance. So she's trying to get Judge Jackson riled up, like, Judge, they're defying the court's orders. Aren't you the court? But it's not a violation. The judge said he couldn't be held in contempt until his motion was heard. So I don't know why that's confusing for her. Number 6, enforce original alimony obligation regardless of respondent's current circumstances. I.e., I don't give a damn if he can feed my son or not. I don't care if he gets kicked out of his house or can't pay his car payment or gas. He needs to pay me first and foremost. And order petitioner to pay $62,000 as estimated and calculated, minus appropriate costs deemed just and ordered by the court. What cost do you guys think she's talking about? So 62 months by 1,000 is how she's getting to the 62,000. Now, to be fair, I would say in question from March 20th. So she got locked up in February, right? It was like February 25th. And so there's sirens. We're in New York and there's a thunderstorm. How's the weather where you guys are? There's supposed to be maybe a flood, flash flood. Anyway, okay. I think the siren's almost gone. She was arrested on February 25th. So presumably he already paid alimony for that month, right? Because it was the end of the month. So come due March 1st, he didn't pay that alimony. And then he didn't file for relief until April, the end of April. So we'll say in 2022, we'll say that is in limbo. I've said this before. Like, I am not a fan of Sarah, but I'm a fan of fairness. I'm gonna give a little knick-knack, paddywhack, give that dog a bone. The judge could say, because he didn't file for relief until April, that he owes her from the March 1st payment to the April 1st payment, because I think he filed like April 6th of 2022. Because he is asking for retroactive, as we saw in his supplemental motion, but the judge could say, well, you hadn't filed yet. Or the judge could say, as soon as she got arrested, you were no longer responsible. But how would the court know if he hadn't filed anything? Do you know what I'm saying? So I will say there is March 2020 to April 2022. So 25 months of payment, or $25,000. He could be on the hook for. And if Sarah were smart, I think it would have more teeth if she held fast on that. Like, he owes me that. She's going to go into arrears, or taxes, and that's all in arrears. She might have a leg to stand on that. But by her demanding the whole $62,000 that she feels entitled to, she's demonstrating that she's not reasonable, right? She keeps talking about how she's reasonable, wants to agree. By still demanding that, and he hasn't been employed for 3 years, and he's a single parent taking care of her son, it just shows she doesn't give a damn, right? It's all about her. So, and then she's talking about included while at OCCD, she likes lists with open, active, court-ordered agreements. So he filed on the 12th here. So it stops at 4/12/2022. There's a pause in payments because his motion needs to be heard. Now, the caveat, shout out to Nancy Brophy, is his motion couldn't be heard until her criminal case was sorted out, because that's what Michael Dean, the prior judge, said. Like, let's have it be more definitive, right? Like, if I make this change, she still hasn't been convicted, but she still is incarcerated. We don't know what the outcome is going to be, sort of. I mean, if you saw the video, you knew. So let's wait until there's some finality about it, if you will. I know Sarah's saying about her appeal, but for that situation, so that they didn't have to do like a temporary and then come back after she was sentenced. Well, we all know she was delaying her trial in 2022. That's when she started going a little bit nutty. So around this time, Padilla quits because she starts bad mouthing him. And then Bankowitz comes on. Bankowitz actually signed on to work for free on her family case. And then in 23, he withdrew from both her criminal and her family law case. And then Hobson came on. So she's causing all these delays with her issues with her attorneys and not being able to resolve them amicably, right? And so they quit. So she's delaying the time that it takes to get to his motion. So she's delaying the time that that she has to wait for her alimony issue to be sorted out. But she doesn't take responsibility for her actions. So no judgment made, no permission, no stipulation. So she's just like, neener, he didn't ask. So then she goes into the months of how she got to it. Whole petitioner accountable for interest accrued on arrears as a matter of equity, law, and appropriate authority, calculated as follows. So again, if we just go strictly by the law, those 25 months, he would owe $25,000 in arrears, and that's prior to interest. Then she goes on to talk about the interest. She uses the interest rate from July 2025, July 1. I don't think that's right. I think she would have to go back. Like, they have these indices of what interest rates were, and she'd have to go back to the interest rate at the time and apply that. She says, she references, like this is all in quotes, this is some Florida statute that she's quoted here, compounding interest. But when she does the interest rate, she only does simple interest, because she does a straight 8.9 by 62. If you were going to compound it, like the very first month, like March, if we're counting March as the first month due, would have more interest on it than the very last month, right? Because it's been waiting longer, it would keep accruing interest. But whatever. So she's adding that on, so she gets to a total of $67,000. Pre-deduction, she wants to specify, because remember, he's been sending her money not only for her books, but he's also been paying for collect calls and tablet messages and all that. So they're in deep. Mind you, on his financial statement, when he was working, I think his last year of full-time employment that he's reported was 2021, and he reported his annual income as $60,000. So the fact that she wants 67 is, say what? Balls of a burglar. Leave it to Sarah. So respondent is requesting $300 to be deposited by the petitioner in her DOC inmate account on the first day of every month until the debt is satisfied, or other arrangements have been made at her request pending her appeal. I don't know why she keeps mentioning the appeal. It hasn't happened yet. Her brief hasn't even been filed. I think like maybe she's dangling that for Judge Jackson of like, don't give up on me. I'm not here always. But I thought this was interesting, the $300 a month when we're talking about 67,000. So I did a little math, a little arithmetic. So if we divide it by 300, that equals 225 months. If we divide the 225 months by 12, so that it equals a year, we get 18 years, 18.75. So I think that is like whatever 3/4 of the year is. What does that get us? Around August, September-ish. Yeah, when is third quarter? When does fourth quarter start? October, November, December. So yeah, it gets us to September, which would be 2043. So she wants him to make monthly payments to her until 2043. Girl, Brian ain't trying to fool with you for that many years. Her son would be 33 at that point. Brian is counting down the years to 18, ma'am, not till 2043. It's crazy, but the reason she's doing that is because otherwise she would have to get someone to have power of attorney. She can't have that much money in her account while she's in prison. And so it would have to be externally housed in some financial institution, and then someone she would have to give access to the 67,000 and trust them to max out her account to 300 every month in the prison, which who does she know that's going to do that? You know what I'm saying? But it just also shows like the ridiculousness of what she is asking for. Like, why would Brian, he was only obligated until 2025. Like, why would he want to carry it into 2043? Like 18 plus years. It just balls of a burglar. Dollar amounts from her financial affidavit needed for her son. There's more money she's asking for, such as communication, gifts for holidays, etc., will be billed accordingly from total amount owed and is separate from monthly payments to her inmate account. Further arrangements can be made, if applicable, upon order of the court after formal judgment has been made concluding trial. Or not formal, further. Did I say formal? So help me with this, guys, because is she saying like that will be deducted from the 67 when she says a billed accordingly from total amount due? Also, the 67 would continue growing because interest would continue to be applied. So I just don't see the judge telling him fork over all the, I mean, he could send his kid to college with that money. Do you know what I'm saying? Like if she really cared. And what could she possibly do? I mean, maybe she's running out of friends. Maybe she's really secretly knows she's doing life like we do, and she can stop pretending, and that's meant to last her until she dies. I don't know. It just further demonstrates her unwillingness to negotiate and be reasonable. Certainly, she doesn't need that money in prison. In conclusion, respondent is not requesting a new award of alimony based on her actual need or circumstances, which would be more appropriate. Rather, graciously asking the court to enforce the original order, which is active during her incarceration, without any stipulation of or permission to modify any part included. She doesn't want to budge. Additionally, respondent is asking court to hold petitioner accountable for the arrears and interest accrued due to actively violating compliance according to court orders in Florida law. I put a question mark there because I think this is not according to Florida law. The law says, based on Rosenblum v. Rosenblum, that he doesn't have to pay while his motion is pending. She doesn't cite which law she's referring to that might override that, but yeah, it's weird. Justifiably upholding the respondent's constitutional rights and proper inclusion while seeing her good faith efforts in patiently cooperating. Girl, patiently cooperating, Sarah? For real? Mm-mm. In every manner possible, even under the added chaos created by the petitioner through their perpetual unlawful attempts of advantageous gain and control of this case as a whole. The petitioner's bad faith also of automatically assuming their success in overruling the court, she's misusing overruling, and taking advantage of the disadvantaged respondent by implementing their rules of not paying or cooperating with anyone. Oh, yeah, you're the cooperative one, Sarah. Should not be rewarded, rather removed and made known to all parties. Authority belongs solely to the court. That's you, Judge Jackson. And orders are given for reasons of justice, formally, legally, and constitutionally. Respondent's motion for contempt, Florida law mandates compliance with court orders unless a modification has been officially granted. So she's taking leave with it, right? He doesn't have to comply while the modification is pending. It doesn't have to be officially granted, meaning he could lose his modification, which that's why I say it's not a cease as an end. It's a pause. He could lose that motion, then he would retroactively have to pay that, but she would just have to wait, right? She can't wait, apparently. I mean, it's next month. Well, this is July 31st, so she's got 25 days and then it'll all be sorted. But she's got a lot to say in the meantime. Petitioner has continuously failed to pay alimony as ordered by the court in the marital settlement agreement and final judgment without any such granted modifications. I hope nobody's playing a drinking game for how many times she's going to say he doesn't have a granted modification. His willful violation of deliberately refusing to comply and without any justification or permission is contempt. He can't be found in contempt until his motion is heard. We're going to get to Rosenblum v. Rosenblum now. So petitioner filed a motion to continue on respondent's motion for contempt, arguing that pending his modification petition constituted a change in circumstances under Rosenblum v. Rosenblum 2015. This case states that a party cannot be held in contempt if they lack the ability to pay, which petitioner does, but actively chooses not to, as ordered, while being encouraged by his counsel to continue such contempt, assuming without any family support, resources, money, an attorney, or inclusion, respondent would surrender to her circumstances and the petitioner. That is one hell of a run-on sentence. So Rosenblum v. Rosenblum says nothing about cannot be held in contempt if they lack the ability to pay. So let's go through that really quickly because she keeps saying it and it's annoying me. So here's Rosenblum v. Rosenblum 2015. Appellant, the former husband, appeals an order finding him in direct civil contempt for failing to pay the full amount. So in this case, there was a hearing. He was found in contempt, but he had a motion pending and his motion was filed first. That's the trigger, right? Had Sarah's motion for contempt been filed, say, in March of 2022, it would have taken precedence. But because it was filed a year exactly later than when Brian filed his motion to reduce or eliminate, his takes precedence. So it has to be heard first. which is what this case is saying. So, as his failing to pay the full amount of child support established, can you guys see that? When the parties married was dissolved in 2003. The former husband filed a motion to modify child support on April 27, 2007, asserting that circumstances had changed since the dissolution and that these changes required recalculation of child support. He also challenged a provision in the final judgment of dissolution stating that his substantial parenting would not trigger any reduction in child support. So challenging it, saying because he has a substantial amount of parenting, that should change the child support, right? That's how Sarah ended up with $100, is because she had a little bit more parenting time. He had a little bit more money. There was a calculation in there. So he's saying he disagrees with it. And I have to be fair. I feel like sometimes men get the short end of the stick in these family court cases. Like the woman gets the benefit of the doubt. But this person, Rosenblum, stood up for himself and he ultimately prevailed. So the former wife filed a motion for contempt on August 8th, 2007, which obviously is after April 27th, asserting parenting issues and arrearages in child support. The former husband intended for all pending motions to be set for hearing together and thought that would be the case, but only the former wife's motion for contempt proceeded to hearing. Why? Maybe she had an attorney and he didn't. I don't know. At that hearing, the former husband objected repeatedly to proceeding without first or simultaneously resolving the issues raised in his earlier filed motion to modify child support. Trial court contemplated a subsequent hearing on the motion to modify, and counsel for the former wife noted that the amount would be subject to change if modified at a later hearing. So they wanted to get their back amount locked in at the higher rate, potentially higher rate, if it was changed and lowered. Former husband was entitled to have his motion to modify heard and resolved before or simultaneously with the hearing on the former wife's later filed motion for contempt. And then there are Arias v. Arias, which reference that. And you see how they cite the specific thing they're pulling from Arias v. Arias when they cite a case? Sarah doesn't do that in her document. So they're citing from that case on appeal from order entered on former wife's motion for contempt for non-payment of alimony, remanding for hearing on former husband's motion to modify alimony. So this is the same circumstance that Sarah and Brian are in, right? He appealed it, had to be heard. His motion to modify needed to be heard before her motion for contempt. Herrera v. Sanchez, and they cite reversing order of contempt for failure to hold a hearing on petitions for downward modification, among other issues. So they gave this Rosenblum v. Rosenblum to Judge Michael Dean, the former family law judge, and he said, okay, this makes sense. I'm going to be reversed. No judge ever wants to be reversed. I'm going to be reversed. There's plenty of case law that says his motion has to be heard first because it was filed first. So then we go to Deutsch v. Deutsch. Holding trial court erred in refusing to allow hearing on petition for modification before adjudicating question of contempt. So we've got plenty of examples there, right? Arrearage is due up to the date the motion to modify was filed were properly calculated on the basis of the child support. So that's where I'm saying it's dependent on the motion to modify when that was filed. Brian didn't file until 2022. So if Sarah had bothered to actually read Rosenblum v. Rosenblum, she would know that the 2020 April till or March 2020 till April of 2022 is ripe for those calculations. He would technically owe her, because he has to go by the date the modification was filed. So there was a specified amount not subject to automatic reduction if any particular expense later changed. We affirm these arrearages up to the date the motion to modify was filed. Any adjustment in the former husband's child support obligation determined to be appropriate as a result of his motion to modify, however, should have been taken into consideration in establishing the arrearage amount, if any, due after the date the motion to modify was filed. See Pierce v. Pierce, noting that alimony could not be reduced for period prior to filing of supplemental petition to modify. Right? It makes sense. So they reversed the judgment in part and remanded for further proceedings. So they reversed the part post date of filing. So we know she didn't really read Rosenblum v. Rosenblum, and it said nothing about lacking the ability to pay. So, however, Rosenblum requires a show of financial incapacity, not merely a change in circumstances of the receiving party, such as incarceration. So that part is kind of mute because they don't go into why he needed the reduction or why it gets to stand on its own merit. If the judge deems that because she's incarcerated, she doesn't have the support needs, that has nothing to, Rosenblum doesn't dictate any of that. It stands moot on there, basically, or mute, sorry. It sounds mute on there. The petitioner fails to present any clear or convincing evidence of financial hardship to prove otherwise in his pursuit to seek relief from his contempt. He's not in contempt. He doesn't need to seek relief from that. And obligation of alimony, other than his unverifiable statement of being unemployed. His argument is legally and factually deficient without proper proof showing confirmation of such status in their attempts to delay the petitioner's payments and progress in this matter. She is barking up the wrong tree. He said nothing about not paying because he was unemployed. He said he shouldn't have to pay because she's incarcerated. In addition to court orders and Florida law, respondent has made numerous legitimate attempts to contact the petitioner while located at OCCD to inquire about her court-ordered alimony payments and concerns regarding her son, vehicle, storage unit, bill payments, where the petitioner would repeatedly verbally abuse and lie to the respondent about promised payments, then tell her to call back or call tomorrow. Don't worry, with the same answer and outcome each time. She would cooperate with him for years. What was the cooperation? I need more details. Both parties were fully aware the final judgment was in effect. I feel like after the judge said he can't be held in contempt until his motion is heard, any communication Sarah had with him begging for this money is harassment, because y'all both know he don't have to pay till the motion is heard. And the motion is not going to be heard until after you're convicted. So, what? Okay. Especially and foremost after the judge verbally reiterated in court, ordering both the petitioner and his counsel to continue payments in the case management conference on September 19th, 2022. So we looked at that in the prior video. No such thing is on the record. Petitioner still refused to be inconsistent in any amount of payment. Oh, so he was making payments. You just didn't like the amount? Is that what you're saying, Sarah? And the respondent, being indigent with a growing negative account balance, filed her motion for contempt to make the judge aware of his violations and willful disregard to the agreement and court orders. The respondent's need of essentials were not being met by the facility, and her outside responsibilities were in jeopardy, which could and should have been fulfilled and saved would the petitioner have been making payments as ordered. How is she going to pay the storage and whatnot? She wanted Brian to be a bookkeeper for her and pay. They don't have checking accounts in jail, right? Was she going to write a check to the storage facility? The petitioner and his counsel unilaterally made the decision to stop her entitled payments. There she is again with that entitled. completely avoiding the court, due process, and her active legal right to alimony. Not avoiding, they're following what the judge said. Their actions are not only unjust, but undermine the capacity and authority of the court with its legal protections that are to reinforce and ensure rules, fairness, support. And here she goes again, citing case law, but not the part of the case law she wants the judge to read. If she thinks the judge is going to print all these out and read them in their entirety to figure out what the F she means and how she's trying to apply it to what she just said, honey, she's got another thing coming. Okay, resolutions. Respondent respectfully requests the court to 1, grant her motion for contempt for lawful reasons stated in this pretrial memorandum, denying the petitioner's motion for continuance and termination of alimony, as his argument lacks legal merit and does not justify non-compliance with active court-ordered agreements and inactive modifications. This has caused the respondent unnecessary financial hardship and loss for over 5 years, with his ongoing unlawful withholding of her entitled alimony payment to prosper in her current circumstances, this family law matter, and her life as a whole. That is rich. I don't think you're meant to prosper in jail or prison, ma'am. I don't think that's what punishment looks like. 2, enforce the alimony order in the final judgment and underlying marital settlement agreement with no compromise. Enforce it just as it is, as if I didn't create or commit any crimes like unaliving my boyfriend. 3, compel petitioner to produce evidence of permission from the court to reduce or terminate any alimony payments to the respondent. 4, impose appropriate sanctions against petitioner and his counsel for filing a baseless motion to continue, unnecessarily delaying proceedings and the respondent's lawfully owed ordered payments to rightfully thrive in her life, needs, and responsibilities, regardless of her status and location. Okay, this is all kinds of wrong. So the motion to continue was granted. So if it was baseless, I don't think Judge Michael Dean would have granted it. But this is, again, the pot calling the kettle black, because she has submitted so many baseless motions that have been denied. Like, girl, how do you fix your mouth to say that? And delaying proceedings. She, again, is delaying it. So let's just take a quick look at his motion to continue the contempt hearing and how the judge responded, so we can just be on the same page that the judge didn't deem it baseless. So comes now petitioner by and through. So on April 11th, 2023, the respondent filed a motion for contempt. So that's Sarah. On April 14th, the court scheduled this motion. 3, the petitioner filed a petition to modify alimony on April 12th of 2022. So a year before, almost to the date. And that petition is still pending as of the date of this motion. Under the current law, the petitioner is entitled to have his petition to modify his support obligations heard and resolved prior to trial court's resolution on respondent's later filed motion for contempt for failure to pay. And that's Rosenblum v. Rosenblum, which we read. Therefore, the petitioner is requesting that this hearing be canceled and rescheduled either contemporaneously with or after the final hearing on modification, right? What did the court say? Order on motion to continue contempt hearing scheduled for May 11th. So having come before the court on April 19th on the petitioner's motion to continue contempt hearing and having reviewed the file, it is therefore ordered and adjudged as follows. The motion is granted. The hearing scheduled for May 11th is canceled and will be rescheduled either contemporaneously with or after the final hearing on the modification. This court expressly retains jurisdiction of this cause for the purpose of enforcing, construing, interpreting, or modifying the terms of this order. So he cannot be held in contempt until after his motion is heard. Black and white. It's not illegal. It's the judge said it was based on the law. Yeah, I don't know what she doesn't get about that. So impose further sanctions to petitioner for failing to obtain legal modification, granting formal permission before reducing, ceasing, I would say pausing, ordered payments to the respondent. One of you guys said she thinks the sanctions would go to her, and I think you're right, because she says that later. She'll later ask the court to direct it to her, but that's not the case. And what this part, the legal modification, failing to obtain, is baseless, right? There's no law to support it. Excuse me, personal property. Then she lists all the property to be divided. This is all moot. This was decided in 2018. You can't reopen this. This is a separate civil case. So state the suggested disposition of such property immediately upon the respondent's incarceration. Petitioner took possession of her vehicle directly from the sheriff's office and secured it at the marital home. Petitioner also proposed and coordinated a storage unit where her belongings from her townhome were placed and secured. And what is the thank you he gets? Harassment, right? He went above and beyond. What is that expression? No good deed goes undone. Poor Brian. So she repeatedly inquired about her property. You guys can read this in full. You can pause it if you want. But basically, she's like, her last ultimate resources, her generational legacy to share, like he discarded that. Her car was a 2011. Even if she would have taken the plea deal, I still think it would have been like 20 years old by the time she got out, because she had already served 4 ongoing years, and then she would have had 7 more, so it's 11. I think it would have been like a 20-year-old car at that point. Was that a last ultimate resource? Girl, I think you was going to need a new car. And who was going to be keeping up maintenance on it all that time? You know what I mean? Like, ain't nobody got time for that. Respondent felt the petitioner was being untruthful after not receiving any updates other than the aforementioned for years, and coordinated turnover of her vehicle keys, lock and keys for storage, with information to be given to her brother who lives locally for safekeeping. So I'm going to say that would only be for 3 years, because Brian left what she's calling locally in 2023. So her timeline is fuzzy for this to have been happening for years, because that's only 3. And like, when did it start? In 21 and 22? She's just not a reliable narrator. Since the last statement made by petitioner, respondent utilized her outside resources to locate information for this case and possibly filing an unlawful disposal suit against him. Go that route. But then she's telling the judge, like, I'm going to sue him because he did me a favor and then he didn't follow through with it. Litigious, vexatious. Found out her vehicle was scrapped and storage unit auctioned off due to abandonment. Yeah, that's what happens when you don't pay for things. And with you constantly complaining that he's not doing enough, he probably was like, oh, I'm going to show you what not enough is, ma'am. Petitioner had a legal duty to return or inform respondent before disposing of or abandoning her property, and should lawfully be liable for total loss and damages of, not appropriate for family court. And then she goes on to list the various values. I guess she's printed out website pages and attached them, website with prices of the value of it. But like, why not just use Kelley Blue Book? She doesn't list the URL, so I don't know what website she used. And then the storage unit as a whole, $10,000. We all saw your apartment or your townhome, Sarah. $10,000 is a reach. Maybe 2,000. And some things don't have a price. Like a childhood friend of mine, her home burned down. And they lost like family heirlooms, like photo albums, but there's not a price you can really put on it. Like, as far as like, if you're filling out a loss document for insurance purposes, you can't put a price. Like, it's truly one of those priceless things, like photo albums, baby shoes, Christmas ornaments that the kids made when they were 5. You know, some of that doesn't have a monetary value. But I'm guessing she's assigned it, you know, a value to it. That's how she got to 10,000, because you guys let me know. We saw those pictures. Did you see $10,000 worth of stuff in there? Respondent is requesting status and return of her personal property. So here she's just wasting the court's time. Respondent, attorney's fees and costs. Respondent continues to attempt to understand her position of defense against the petitioner and his request to charge her with his attorney's fees. As in the supplemental petition, it states, due to not signing their joint stipulation and in their pretrial memorandum, resulting from the chaos created by the respondent's criminal conduct. So, 2 things can be true. And she keeps saying she didn't sign the joint stipulation. It wasn't sent to her. We'll get into it. But we're in 2025. Why haven't you signed it now if you're so willing to sign it? Then we don't have to even go to the trial in August. I mean, we want to go. But I'm just saying, you could sign it now. You could redline it and send it back and start the discussion that way. So to keep saying she's so willing to do it, well, then why haven't you done it to date? The petitioner's counsel did not ever attempt to come to a resolution of these issues with the former wife without the necessity of filing a contested supplemental petition for modification. So he had to file that to start the clock on when he was not going to pay anymore, when he was going to pause payments. As stated, nor the former wife would not sign the joint stipulation, which resulted in the filing of this action. This supplemental petition to modify was received via summons to the respondent with no other correspondence, because it was a legal filing, or notice of any kind provided prior, as suggested to avoid any presumed costs incurred from this filing by the petitioner. Well, they did try to do a mediation with her, to be fair, but okay. To clarify the untruths for the court to fully understand their self-inflicted costs and confusion, the timeline is as follows. So then she goes through the supplemental petition was filed. It was signed on February 18th, but as we discussed, it didn't get into the court doc until April. And he switched counsel in between that time, so that might have caused the delay. So the summons was sent by process server. They sent a process server to the Orange County Jail to her, and it included the notice of appearance. So Josh came on the case, supplemental petition for modification, and she notes that it was served 2 months after originally signed. I don't know why she thinks that's important. The filing date is what's important, and I believe it was April, whatever. Joint stipulation for modification. So she got the joint stipulation. All she had to do was sign it or redline it. And then the uniform child custody jurisdiction affidavit, which is a requirement. Then April 21st, summons received by process server to be delivered to her. Summons and inclusion delivered to her. I don't know why we need to know all those dates. Respondent's answer to summons sent to petitioner as instructed, which we didn't get to see. It says here, respondent's answer filed with the court by petitioner, but I could not find a May 16th filing. Or wait, was this other one May 16th? No, I have a July one, but I couldn't find the May 16th. Anyway, petitioner's correspondence attempt with respondent to schedule a mediation. And then her answer and transparency to correspondence confirming her want of participation with concerns. She never said she wanted to participate. This is when we all found out she had cancer. So this is where she is like, I am in receipt of your letter requesting a date to be set for former husband's petition to modify, but have a few concerns and questions before doing so. First, I would like to make it known I've been diagnosed. I'm not going to go into that. She's like, I do not know 4 months in advance my location or status. Well, girl, you're going to be in somebody's jail, making it impossible to determine the best state to choose from, which you have proposed. With that being said, my questions are as follows. What are the requirements under Florida law stating a mediation needs to be scheduled for the petition to modify? So that is hinting at you don't even think you have to do a mediation, right? And he can't give you legal advice because that would be a conflict of interest. He represents the opposition. Please provide documentation so I can understand the practices, not his job. Please provide copies of all documents to be discussed, which include original marriage paperwork, pre-modifications, to see and compare specifically what is being requested to be modified. 3, please send contact information, location, and credentials of the selected mediator, Karen Middlecoff, Esquire. What is her affiliation with the Martell firm and how she was selected? Will former husband be in attendance? Who all will be included? Who is the judge overseeing this case? It's the same family court judge. 6, is there going to be an agenda for discussion during the meeting to be received in advance for preparation and review? 7, what if selected date has to be changed? 8, is the point of this mediation to try to force me into signing and agreeing? So she goes on and on. What if I do not agree? How is a video conference scheduled? Will this be a private meeting? Is face-to-face an option? As said, I do not know what date is best for me considering my current situations and now health complications. By answering and explaining further the aforementioned concerns and questions will most definitely assist in my decision making. So decision making about what? About going to participating in this mediation. So she did not agree or seem willing. She had demands, conditions upon which needed to be fulfilled before she would make a decision. But in her eyes, answer and transparency in confirming her want of participation with concerns. Okay, girl. A motion to dispense mediation. So they immediately filed, like, we are not about to go back and forth with this woman. Let's just dispense with mediation. And the court granted it. Filed by petitioner claiming the respondent is refusing to coordinate. She was. If she wanted to coordinate, she would have come back with some dates and times. No hearing held. Respondent not included or able to defend herself against another refusal accusation made by the petitioner and his counsel. So she's basically is going to go on and on through these. You can slow it down. No joint stipulation was ever sent to the respondent before the petitioner filed their supplemental petition. So that was in 2022. Again, it's 2025. You have the joint stipulation. You've said it in here. Why haven't you sent it back now? Because of their untruthful statements, also an improper handling of these documents, the joint stipulation, foremost, not being received by a respondent prior to their supplemental petition to modify, her right to mediation was forfeited, which has been avidly and emphatically sought by her since the beginning of this case. No, her unwillingness to give dates is why there's no mediation. She forfeited the mediation. So a respondent was never given a lawful opportunity to participate appropriately, as with many other missed opportunities caused by the petitioner and his counsel's undeniable wrongdoing against her throughout this case. She's just hurling accusations. She was given an opportunity. They sent her a letter. They asked her which dates would work for her. What are the best dates? And I just read you her response. So you guys tell me, did that seem like she was willing to participate? Or did that seem like she was trying to control the situation? Regarding the respondent's accused chaos in her incarceration and the time to present, the only chaos generated has been from the petitioner and his counsel's uncooperative, disruptive attitude, which has made this entire process more arduous and worse for herself, their son, and the court. That's you, Miss Jackson. Both have committed perjury on multiple instances in writing and verbally to the court. Oh, that's the pot calling the kettle black. This whole document is filled with perjury, Sarah Boone. ignored the judge and respondent, and continued to be a part of the problem instead of the solution, which the respondent has ceaselessly attempted to generate to be a part of her case completely. Okay, this next one is word salad to me. Y'all tell me what you think she means. From her cooperation, attempted solutions, and ongoing answers, resolutions, and provisions could have been made in avoidance of trial, all cost included, and continued disruption for all parties. Many items could have also been solved with the meeting of attorneys and unrepresented parties been scheduled as ordered. This is a further example of the petitioner and his counsel's added chaos and not the respondents. So that is just finger pointing. Like, I am trying for solutions, they're not trying for solutions. Another example is that, but I'm not sure what her point is, other than she just doesn't want these attorneys' costs attributed to her. Respondent has been transparent, properly corresponded when prompted, provided innumerable solutions, vigorously attempted to be included in this case by the petitioner and his counsel, and cooperated in every manner possible throughout the entire process. If that is cooperation, I hate to see what resistance looks like, ma'am. Ma'am, wait. The petitioner has and still does not include the respondent in their filing. So then she goes on to go back about, she's commented on that. The judicial assistant for Michael Dean has commented on that and warned them. There's no evidence of that. I couldn't find this letter. She says it's via email, but I would have thought it would have been put in the court file, but whatever. How did Sarah get an email? Because she's on a tablet. She can get tablet text. But she goes on to talk about Henrietta Coffey. I circled she here because that's the last person she mentioned. Well, I guess she said include the other party, which is the respondent. Just, this is a new paragraph, a new idea, like, say who you mean, ma'am. She also, on more than one occasion, has been unfairly ambushed by trial from no inclusion by the petitioner where she believes she was being transported for case management conferences. She would request from constant exclusion and having no status of her case to be properly prepared to defend herself and attempt to represent herself as pro se, which petitioner and his counsel advantageously try to have control over. Again, more word salad. It's not Brian and his attorney's job to tell her when she has a case management conference. It's the court. And I mean, listen, if they tell you by kicking your bunk and telling you you have court, get up and at them, girl. To date, petitioner and his counsel do not include the respondent, take advantage of her circumstances, and discredit her truth in her pending appeal. That is in process to disprove her charge and bring forth her proposed release. How is that relevant to what we have to talk about on August 25th? In their intentional exclusion and perjury, she should not be responsible for any supposed attorney's fees incurred by their attempts to continuously sabotage her lawful attempts to be successful in this case. How are they sabotaging it? Can you give any specifics? The result of their growing unnecessary costs is due to the petitioner and his counsel being uncooperative, stating ongoing untruths, false accusations, causing innumerable violations of the respondent's due process and proper lawful inclusion. Their actions and failure to act ethically, lawfully, and truthfully necessitated their own attorney's fees. All attorney's fees were and are self-inflicted by the petitioner and his counsel. So why haven't you signed the modification? Okay, then again, with her case law, without citing what about the case law is applicable. Resolutions. Number 1, respondent requests from the court to deny the petitioner's proposed award of any attorney's fees due to their intentional and strategic exclusion of the respondent in their relentless attempts to control this case, including the court. That's you, Judge Jackson. by overruling and ignoring, committing perjury too. So the respondent is accused, uncooperative, and defiant. It is the petitioner and his counsel who are so. Number 2, respondent requests an award of attorney's fees due to financial hardship. Now, this is the balls of a burglar, because just a couple paragraphs ago, she went on about being pro se. So you can't be both pro se and have an attorney, and there's no such thing as pro se fees. And of course, she has to throw in that financial hardship. Girl, we get it. You broke. And loss caused by the petitioner's failure to pay alimony with active agreements, court orders, and without modification for over 5 years. Respondent requests sanctions to the petitioner's counsel for his unethical treatment to her as a disadvantaged party in this case. Continued exclusion, confusion, defamation. It's not defamation if it's true, ma'am. So she cannot properly defend herself, encouragement of the petitioner to remain uncooperative, and blatant defiance to the court in ignoring orders, undermining its sole authority. So by now, the judge has seen Brian's parenting plan. I don't think anyone would say that he's uncooperative. I thought it was a very, very generous parenting plan. But, Sarah's going to paint the picture. I just wonder if this is how she sees it. I mean, or is it just all gaslighting? Like, is it a level of cognitive dissonance where she can't see what we can see? It confuses me. It perplexes me. But for anybody who's ever been gaslit, yes, it's real like this. It's very, they will just make up stuff. And things that aren't true, they will keep repeating it over and over until you start to question yourself and your sanity. Brian probably put up with it for years. And even if he knew he was being gaslit, he probably just got tired of going round and round and round with her. It's like a circular conversation. She could have cut this down to like 3 pages. She repeats so much stuff. So then she's got to give trial exhibits and witnesses. She's calling herself as a witness. She's calling Brian as a witness. She's calling Philip as a witness, which I think is interesting. So she has all of these exhibits. You guys can check them out. I think some of them are redundant. What I think is kind of interesting is the exhibits that she lists that she couldn't get in. Like if the judge couldn't, oh, that's interesting. She put in her certificate of destruction for the vehicle. The judge doesn't care. Then canteen items with pricing. Judge doesn't care. GTL communication, current pricing. That's the telephone. And then JPay, which is the tablet. Features and current pricing. So it's not good enough to just use it for messages. It's what the videos are: pictures, messages, stamps, videograms, more. Also movies. Remember Lana and Christina sent her money for movies. Okay. The exhibits attempted by respondent to submit. The jail and prison recorded phone calls were denied. The tablet messages to demonstrate no response was denied. Copies of case documents from clerk, $414, unpaid. I believe Brian has entered those, so I'm not sure why she needs duplicates of it, but whatever. Her petitioner's complete financial documents denied. So that's when she motioned with interrogatories to get more in Brian's business about what he did with the house he owned. Motion for counsel to be appointed was denied. This is not a criminal case. It's civil, it's family. You don't just get a free lawyer. Motion for guardian ad litem denied. Mind you, these last 3 were denied by Judge Jackson, so she knows. I'm not sure if Sarah thinks she's like making a clear record for her to appeal this, but all of that is already in the record, so I'm not sure what she's doing. Letters to former counsel. So she's talking about Owens, but Owens never represented her in this case. He looked at some of her documents, but he never officially filed a notice of appearance of being an attorney on her family case. But she has to put in the irreplaceable case documents. Well, are these different than the documents that the court was charging you 414 for? Because if that's the case, it's not irreplaceable. Anyway, no response. Request for classification. I'm surprised she didn't add, because she also put a motion in for the judge to compel, but the judge has no jurisdiction over Owens because he wasn't the attorney of record for her. Request to classification department regarding visitation. 8, not processing to date. So that's her with the Department of Corrections not getting the application for her son or Brian to visit in person. Letters to petitioner regarding visitation applications. 2, no response. Tablet messages to petitioner regarding visitation. 18, ongoing 8 months after court orders to submit, no response. So no court order, not ongoing 8 months, because when she was in the women's reception center, she couldn't have visitors. USB drive from clerk of courts for trial, waiting for 2 months to view from DOC. 7, requests to classifications department. So she has that USB. I just got her updated Department of Corrections reports. So maybe she got it after she wrote this, but why? Maybe it's the discovery from Brian's team. I'm not sure, but she has it. She just can't access it, but she needs to let the judge know her hardships. Transcripts from case management hearing 919 stating petitioner to continue payments and constitutional rights violations from judge unpaid. I'm actually surprised there were transcripts. A lot of these case management hearings, there's no transcriber or stenographer. Respondent graciously requests the court's understanding and consideration in the crucially limited supply of her exhibits, seeing her good faith efforts to obtain many others, but unlawfully withheld financially from non-payment of court-ordered alimony from the petitioner, unresponsive parties, and denial from the court. That's you, Your Honor. Give me grace because you denied me. Due to her inexperience as an attorney in representing herself pro se. That's not why you were denied, ma'am. You were denied because your requests were foolish. There was a lot of foolishness and chicanery. And Judge Jackson said, denied. She has ceaselessly remained proactive in her parental and representation attempts in achieving truth, justice, in the American way. Success in her present and undetermined circumstances to the best of her limited abilities. Sorry, Sarah, when you're pro se, you have to be treated just like you're an attorney. You don't get special accommodations, and your being in prison is your fault, not the judge's. Judge George asked you to let him out of the suitcase. Had you followed directions, you would not be where you are. Request for amendments to pleadings, none. Then she repeats all of this about her marital settlement and all those things with no expiration or some expiration. Any issue the party wants to address at trial that is not addressed above. She wants to go over her vehicle. She wants him to explain why he lied about the vehicle, sign a document that he willingly abandoned the vehicle. No, girl, what you should have had him sign was a document saying he was taking responsibility for your car and your storage. That's what you should have had him sign. Why would he sign something now? The stuff is gone. Why are we still talking about it? Return all property in his possession. Respondents request to produce and interrogatories. So this was denied by the judge. I'm sure the judge knows that. What is Sarah's point? Y'all tell me. This request was sent to petitioner's counsel to further her evidence of ability to pay alimony by the petitioner to the respondent after finding information from the limited bank statement she received prior. So just use the limited bank statements. If there's information there, but he never said he didn't have the ability. So you need to focus on the part of you murdering your boyfriend and being incarcerated as the reason why he doesn't want to pay you alimony. And why should he? Like, you didn't have sense enough to open up a suitcase? Why should he pay you for that? And still have no contrition over it, but you've forgiven all of us. In her itemized research and calculations with petitioner stating he was unemployed, quote unquote, with no means of income, I don't think he stated on there he had no means of income. Knowing from previous verbal statements he made to her he was working contract and had been since her incarceration, the spending totals did not suffice the income. Okay, so what is your point in this regarding the request that was denied? Petitioner filed an objection citing timeline to submit their production was improper and the information respondent was requesting irrelevant. So she asked for it to be 14 days. They'd give it to her and they're required to get 30. That's what she's talking about. But the part about being irrelevant is like most prevalent in the argument, in the response. She says she sent a second set. I couldn't find that on the docket either. And she said, now with this case in trial, the respondent is confused what the point of the objection still waiting for judgment is. She has already been restricted access to this vital evidence in the meantime of trial and her preparation for in full application of. I think she's saying because the trial hasn't happened, what difference does it make if she asks for it in 14 days? But those are not connected. Like the law says they have 30 days to produce. So she could have resubmitted, I guess, with the 30 days, but that doesn't overcome the relevance part, right? It's not relevant whether he has the ability to pay her or not in order for the judge to decide on his motion, because his reasoning is she's a criminal, not a smooth one either. Smooth criminal. Any outstanding motions? So this is what I am not sure about, because you're supposed to list the outstanding motions. She puts none, but she still has the outstanding motion of contempt. So I would think she should have put it here, but I'm not a lawyer. So then request for judicial notice. Respondent respectfully responds to the petitioner's request for judicial notice in their underhanded pretrial memorandum regarding notice of the entire docket of her criminal case. Oh, she is salty about them bringing up the fact that she's a murderer. She firmly asserts her criminal file is irrelevant to this family law matter, other than the fact that she has been incarcerated over a momentary time period, and with a pending appeal, the petitioner does not mention with opportunities for her proposed release. The issues before the court in this family law case pertain to civil obligations and rights, not criminal conduct. The respondent's entitlement to alimony, child contact, and parental relationship, and related relief arises from established legal principles in family law, which are not negated by incarceration. Are they negated by murder? Just asking for a friend. Furthermore, introducing criminal records into this proceeding serves no legitimate purpose other than to heavily prejudice the court, slander the respondent, and distract from the actual issues, such as needs, financially and parentally, with lawful compliance and inclusion. So it does matter, Sarah, because he's saying the reason why he doesn't want to pay you is because you committed a crime and are convicted of it. So that is material to his argument. That is the foundation of why he wants to reduce. That is the reason why he now is the single parent that he is. That is the reason why you are under the care and custody of the state of Florida. I don't know how we, what is the word, extricate from that? Like, how do we pull that out of this? Furthermore, in the petitioner's continuous, vexatious, and strategic attempts to make their own rules disadvantage the already disadvantaged respondent with the unethical encouragement and direction of his counsel to do so, and how, we're going back to our gang. Is that Spanky? Who used to say that? Alfalfa? And how the respondent respectfully requests the court to take judicial notice of their entire docket of violations, contempt, advantageous exclusion of the court and respondent, intentional confusion, while displaying an ongoing flagrant invincibility to any consequences for their continuation of, in the entirety of this family law case, in all matters included. Okay, so she thinks looking at the court docket looks bad for Brian. Alrighty then. The court is respectfully urged to focus on and take under serious consideration all of the facts included in this case historically and relevant to the law, and disregard any attempts by the petitioner and his counsel to use unrelated criminal matters to sway its decisions unfairly or unlawfully. No, let's take it into consideration. If the law does not take that as a reason to stop, we should have that on the record as a reason to stop payment. If incarceration and or / murder is not a reason, we want to know. The respondent also respectfully requests from the court to take notice of the petitioner's payments described in their supplemental petition for modification, stated as being voluntary deposited money into the former wife's account so that she may purchase items from the inmate commissary. These voluntary deposits made by the petitioner are not pursuant to any court order or alimony obligation. They were willingly made by him after her concerns were made known of her needs not being met by the facility, and should not be deducted or applied in any way towards legitimate alimony payments the petitioner has yet to make to her since she has become incarcerated from 2020 present. So I put over here dry begging. Her made known. He, being of kind spirit, heard her problems and sent her something to help solve the problems because she was dry begging. And now she wants him to get no credit for it. No good deed. The judge sees what we see. These added funds to the respondent had no agreed upon rules, stipulations, or attachments as such, including repayment. He never said repayment, but he did want them deducted, like as he should. Oh my God. I hope he doesn't send you a dime after this. Other than being simple voluntary contributions made to her by the petitioner and stated by his counsel in their proposed petition as. No court-ordered alimony payments have been made or obligations met to date to the respondent by the petitioner since her incarceration. Okay, so we at least agree that him taking the car and the storage were not an obligation then? 3, respondent requests judicial notice for the overall undeniable misconduct of the petitioner and his counsel's unethical practices used throughout the entirety of this case and his representation, including advantageous mistreatment of the respondent in this case as a whole. Okay. Petitioner's counsel's continuous, deliberate misrepresentation and insubordinate actions have undermined the integrity of the court, its sole authority, and proper proceedings under Florida law, constitutional rights, and procedural fairness to all. As a direct result of these violations, making this case unfair and unequal, the respondent respectfully requests the court to deny the petitioner's supplemental petition to modify, as it would be unjust to reward such dishonest behavior and inappropriate example of the law. Sanctions for both the petitioner and his counsel should rightfully be applied in the favor of the respondent for such action. So see, she's asking for the sanctions to go to her. They actually go to the court, and which she respectfully requests from the court in the conclusion of this case and family law matters. They hurt my feelings. So because they hurt my feelings, I want Brian to take even more money out of the household with my son, and not only just sanction him, but give me the sanctions because my feelings were hurt. Girl, if you don't put on your big girl drawers and quit it out. Citations are copies of any case law to be argued at time of trial. Please see each section completed per the uniform order with case law included for application in and of. So they did not give. They gave the case law, but they did not give citations. And I don't think they're giving copies of the case law with that, but directions. Whether there will be a court reporter and or interpreter. So she says the respondent requests to have a court reporter present to record, but due to her indigent status, has the inability to pay for. If that ain't dry bagging, I don't know what is. Good faith estimate. So she was supposed to give an estimate of how long that she thought the trial would take. This was due before the judge set the trial. It's already set at 3 hours, so this is really like pointless. And she never answers the question. She's just like, respondent simply and respectfully request from this honorable court to be heard. Like, I don't have a time limit. I just need you to hear me, understand in her explanation and truth, and considered in all aspects as such, as does the petitioner, to maintain an equal level of the law and due process in her inexperience and uneducated attempt to rightfully represent herself as pro se in this family law trial. I'm surprised she didn't put a heart at the end. In regards to a time frame for this to proceed, she is cooperative in any manner necessary for her full inclusion and opportunity in respect of the court's time and considerations. So basically, she doesn't know, is what she's saying. She has no idea how long her case in chief is going to be. Respondent's handwritten financial affidavit was accepted, but she was supposed to send in a typed one, which we haven't seen, and it sounds like she's just like, well, you accepted that, judge. Go on, girl. So that's the end of what they asked for. Then she has this supplemental petition for modification of final judgment. Inactive during respondent's incarceration of 2020 to present. I think she's referring to, what Brian has filed. She's saying that is inactive. It's not necessarily inactive. It's pending. Then she goes, substantial change in circumstance. So she's addressing what Brian wrote. Petitioner seeking to modify shared parenting, terminate alimony and child support, which shared parenting is automatically modified once one parent is incarcerated. She can't have overnight. She can't pick him up from school. This document was filed over 2 years after respondent became incarcerated and has no judgment to date. The court knows that. That's why you're having the trial on the 25th. The final judgment and parenting plan are open and active before and after this filing. On paper, yes, but you can't have overnights. You can't have every other holiday, every other year. Like, just stop it. Okay. So no signature has been executed by the respondent on or in this inactive document she received via summons while at OCCD after not being included. Document has not been heard in court, nor a judgment made, has been self-implemented by the petitioner and his counsel, who willfully violated due process and standing orders for over 5 years by refusing, __, to acquire judicial modification and permission through formal proceedings. I don't see how it being stayed until after her criminal trial can be misconstrued as a refusal by the petitioner. The court said they cannot or would not like to hear it until after her criminal case is resolved. That's not Brian or his lawyer's fault. Termination of alimony discussed and proposed in Section C, alimony of respondent's pretrial statement according to the uniform order. That's where she has no flexibility. She wants it all. I want it all. Both parties have mutually agreed verbally in court. The respondent is not seeking to collect these payments. So she's talking about the child support. She is asking for the sum to be distributed to their minor son and for the respondent to be included in deciding how the fund should be used properly and accordingly. Why? That's Brian's money. He's giving it to his son. Why do you need to be involved? That just seems like an extra layer of complexity for no gain. So attorney's fees and costs discussed and proposed. Attorney's fees and cost of respondent's pretrial statement. She has no attorney, so what fees? What did it cost you to type up this statement? Peter's charging you to type up stuff, girl? In addition and conclusion, the respondent would like to reiterate to the court, she has been proactive, eager for involvement, proposed numerous solutions, like don't change a thing. That's always a solution. And cooperated in every manner with the petitioner, his counsel, and the court since the beginning of this case. Really? Back to 2018? Girl. Okay, Sarah. Going to trial is a direct result of their egregious decisions to be non-compliant with multiple court orders, which could have been avoided from opportunities to collaborate, simplify, even conclude this matter prior to save time, money, effort for all parties. The court foremost. They're wasting your time, Judge Jackson. This only makes sense if they gave her everything she agreed to. Because she could have signed, like I said, she could have been done signed. She wants it all and she wants it her way. There's no like room for negotiation. She's inflexible. The respondent should not be responsible for the petitioner's perjury, self-confusion, and lack of ability to maintain their manipulative attempts to strategically sabotage her in this family law case and in their poor examples of professionalism, ethical practices, lawful and respectful treatment of the respondent and the court. Does she mean unlawful and disrespectful? The respondent is profusely grateful for the court's invaluable time, patience, understanding in seeing her ceaseless good faith efforts and determination in achieving rightful success in her son's life, lawful obligations, her appeal, and productively moving forward regardless of time, location, or circumstances. She had to throw that appeal in there. Okay, she served that there. Then she's got her whole motion for contempt and to compel. This is a new one that she's done in. We're going to go quickly because I'm trying to keep this under 2 hours. Respondent's motion for contempt and to compel petitioner to submit visitation applications immediately. So this is the new motion separate from the contempt of not paying, right? But again, she didn't list it in that spot that said additional motions, and the judge said all motions have been heard. Maybe this is considered within 10 days and she will acknowledge these and they'll hear about it. I don't know. But I did look at the conditions for her to have visitors in person since she stressed that. And Brian will have to go in because the child is a minor. And I believe he has to sit at the table with them. So remember before when she was talking about Brian's like intruding in their visitation, he's going to be sitting right there. I don't know how that's fair to Brian to have to go in and sit and listen to them talk twice a month, 1 to 2 times a month. Why can't they do video visits? Maybe they go in person like once a quarter. I don't know. I just like, I'm trying to be equitable of like what would be fair. Like just blanketly fair to a mother, a child, and a son. But then I factor in the Sarah part and it's like, oh my God, that would just be torture. Okay. Respondent's motion for contempt and to compel petitioner to submit visitation. So comes now, Sarah Boone submits her motion for contempt and to compel petitioner to submit visitation application immediately after raising her concerns to the judge, as stated in the order after case management. So there's no order that he has to submit. He said he would attempt to look into it. The respondent, it was completely non-committal. The respondent has repeatedly been requesting from the petitioner to submit the visitation forms since her transfer to DOC in January 2025 without completion to date, and other innumerable reasons, excuses why he has not or cannot for ongoing 8 months. This is the reason respondent made the emphatic, wait, we're in July. How is that ongoing 8 months? And she couldn't have visitors the first month. I would say 6 months, girl. This is the reason respondent made the emphatic decision to verbally motion the court in the conference to make aware his ongoing untruths and difficulties in withholding her son from visiting and for no valid reasons. Okay. Petitioner's counsel even volunteered to submit these applications on his client's behalf after being sanctioned for non-compliance of scheduling the required in-person meeting of the parties for the pretrial conference. Was he sanctioned? I think he was just reprimanded. Also stated in the order filed May 30th, 2025, where to date, and after the court giving a 2-week due date, no applications have been received per the DOC Classifications Department most recent update to the respondent on July 12th, 2025. Respondent has sent multiple tablet messages to the petitioner requesting status. That is thunder, y'all. Ooh. Okay, where were we? Most recent update to the respondent on July 12th. Multiple text messages to the petitioner requesting status, even completed the applications for both and mailed with instructions they only needed to sign and add work information. They don't have to add work information. Did I show you guys? I showed you Peter's, right? Oh my God. I think I did. Just in case. I'll show it again. Here is Peter Gunthel's application. I think I did show you. Okay. In her letter, she also explained again to him the importance of her desperately trying to still see her son, and during one of his 100 days of summer before starting school, and after over 5 years of waiting prior, in a simple video visit. She had plenty of video visits, so I don't know what she means there. Petitioner has not responded to any of her messages or letter, and upon answering a call from her from no responses, swears and tells her he'll check on it, then disconnects. This is the same reason he gave the court, still with no application submitted by either. The reason is he'll check on it. I think the reason is stop bugging him. These false statements made by the petitioner under oath and his counsel, in addition to their deliberate continued chaos, quote unquote, and noncompliance, is contempt. Wherefore, pro se Sarah K. respectfully requests from the court to 1, compel petitioner and or his counsel to submit the visitation forms immediately for her son and himself, remembering the process takes already a minimum of 30 days to process. Number 2, sanction both for perjury. Where is the lie? Ignoring and disrespecting the court and respondent, causing now she's on par with the court. Causing emotional distress to the minor child in his continued attempts to see his mother, and violating the respondent's parental rights in avidly seeking and growing her parental relationship with her son. Is now a good time to mention to the judge that she would sometimes forget to pick him up from school? It's interesting that she wants to, now that she has a lot of time on her hands and she can't be drunk all day, that she now wants to grow her parental relationship. Maybe picking him up from school, remembering without Brian calling. Maybe that was a good time, but better late than never. Order such relief or disciplinary action as this court deems just and proper. What do you guys think she means by disciplinary action? Like put him in jail for a day for contempt? Like what kind of disciplinary action? Respectfully submitted on this 20th day of July, 2025. And then that's it. We are, I believe, at, yeah, that's the 33rd page. So what do you guys think? What do you think the judge will say? I mean, she's just proving she's unfit, but it's pretty freaking scary. Like the cognitive dissonance, the gaslighting, the like, ma'am, what planet are you on right now? What are you talking about? I just can't even imagine like the judge reading this. I wish I could have been a fly on the wall and seen her face. Like, it's really, really out there. And I don't understand why one of her 9 third-party representatives didn't like kind of reel her in. It just demonstrates like her unreasonableness, her selfishness, her really out for number one. You know, she wants to sanction Brian. She wants him to pay her, what was it, $67,000, $300 a month for the next 18 years and 9 months. Like, Brian is divorced from you, ma'am. Why do you keep trying to like reel him back in? He doesn't owe you anything, no matter how much money his family has or how much they want to give him. He doesn't owe it to you. He just doesn't. Yeah, I don't know. And it makes me more suspicious of the Delapines, like, continuing to help her. Are they trying to get some of that 67,000? Like, what's in it for them? Do you know? It's more than humanitarian effort. Honestly, and I wish if she got it, they would make her pay it to Georgia's kids. Truth be told, if for some strange reason the judge were to grant her the 67, I think at most she'll get 25. Like, legally, I think she's entitled to that because of his delay in his filing. But all that other stuff is foolishness, and I would just send her a cashier's check. That's her problem about being incarcerated and only being able to have $300 in her DOC account. What does it have to do with him? Why does he have to go above and beyond? You know? He's a single parent. He's busy. I'm a single parent. I know what busy looks like. He ain't got time for that. All right, guys, let's talk about it in the comments. I'm exhausted. She exhausts me. I don't know how Brian did it for 13 years. God bless his soul. Wow. I'll talk to you guys later in the comments. Toodles.